Well, good afternoon, everyone. My name is Mark Joseph. I'm the litigation director at the Democracy Fund, and I just got out of the sentencing hearing for Tamara Lich and Chris Barber. This comes after 45 days of trial, and now it's moved into the sentencing phase. So the Crown began their submissions with the position that this was an unprecedented event. So the Freedom Convoy that occurred in January of 2022 in Ottawa and other areas of Canada caused such disruption and such harm that the normal jurisprudence in the case of a mischief charge for which Lich and Barber were convicted doesn't apply. So that means that normal sentencing provisions that might range from days to months for a criminal conviction for mischief should not apply. The Crown was seeking 7 years custody for Tamara Lich and 8 years custody for Chris Barber, plus the confiscation of his truck Big Red. Now their position, as I mentioned, was that normal sentencing for mischief doesn't apply. So in order to establish that, they suggested that there was approximately $15 million in business disruption plus $53 million in additional policing. There was harm to residents, which meant that they were fearful. They suffered some abuse. The downtown core was closed. The Crown read in some victim impact statements, but essentially that the mischief in the normal sense here doesn't apply. So Diane Magus, counsel for Mr. Barber, then got up and she averred to cases surrounding the G20 protest, which involved much more violence. In fact, violence and intimidation that was not present in the Freedom Convoy protest. So she essentially tried to distinguish this case from the G20 case by saying the G20 case involved a lot more violence and intimidation, and in many cases those protesters convicted of mischief didn't receive custodial sentences. So she argued that it certainly should not apply here for Barber and Lich, where there was no violence, intimidation, theft, assault, destruction of property, etc. Now she ended by reading in letters of support for Mr. Barber, some of which were quite glowing. There was some back and forth with Justice Perkins McVeigh about the principles that should apply, denunciation and deterrence. It was noted that Mr. Barber's bank account, both personal and corporate, were frozen, and Ms. Magus argued that that should constitute specific deterrence and possibly general deterrence. But the upshot is that Ms. Magus argued that her client should face only a discharge. He has a trucking business and he's going to be going across the border, and if he gets a criminal record, that would interrupt his trucking business, and he uses that obviously to support his family and earn funds. So she suggested a discharge is appropriate. In the alternative, a conditional discharge, but in no circumstances should Mr. Barber be going to jail. He already served 2 days in jail. Ms. Lich served, I think, 43 days in jail, so that's counted differently because it's pre-conviction jail time. So that's where we stand today. We go back tomorrow to hear from Lawrence Greenspan and Aaron Granger, their counsel for Tamara Lich. Of course, TDF will be here to live tweet for that. If you like our work and you wish to support us, you can find us on X at TDF_can or online at thedemocracyfund.ca. We're entirely donor supported. We don't take government funds, so we look to our donors to support us in any way we can. But I will see you all tomorrow for further live tweeting. Thanks very much.